the involved parties in the network. I think it would also help in terms of, so that would be first of all personnel capacity. There would be also resource input from partners, and I would think of those two as the important outputs, and also the hybrid of the law that comes then from that kind of integration and relationship.
Thank you, Honorable Sijak.
Thank you to Chair, Vice Chair.
A microphone, sorry. Thank you very much, Commissioners and Judge. I believe you are very tired by now.
I'm okay, my lady.
But we are about to complete. Just one clarification from you. When we called out for the applications, there was a list of documents you are supposed to provide. We called for these applications. The advertisement was on 13th January, and it was closing on the 17th of February. And we give instructions on how you are to apply and the documents you provide. The list of documents are many. You provided others, except you did not provide a current declaration of income and liabilities as at the making of the application using the prescribed form. What you gave us was the previous declaration you had made for the Court of Appeal, which is dated income for the period 20th January 2025 to 31st December 2025. You are
my
supposed
lady,
to
do I have your permission to refer to?
To refer to the...
I have a copy.
Yes, I think that's the one I'm also referring to, the one you filed.
Yes, which page, my lady?
The one I have, show him. Yes, you have seen what I meant, that you are supposed to, when you are making the application, you are supposed to fill in that form for that period when you are applying.
Yes, my lady. I have been shown by the registrar. As you can see, the declaration is dated January 2026, I think. Which is the date it was filled, and the status of the assets between the time I made the previous application and the time I made this application, the assets had not changed, and so that is the answer I have for that. Secondly, my lady, is that my understanding of it is that the world declaration intervals would be after 2 years, and but the declaration I had already made, I had labored under the impression was adequate to that extent. So those two reasons, my lady, that the assets had not changed, and secondly that it was still within the time of my last declaration.
Yes, you see, this was a requirement for the application, for every applicant.
Yes, my lady.
To complete that form, even though you had completed earlier, you should have just completed and said the assets are the same, completed and followed the instructions as per the advertisement.
Yes, my lady. My understanding is that I'm in compliance, although I stand to be corrected. My understanding is that I'm in compliance to the extent to which to the extent to which I've just explained in the answer I've just given,
yes.
my lady. Let me not belabor the issue.
Very well.
Thank you.
So I think this brings us to the end of the interview this afternoon. Sorry it has been drawn over the time that we had indicated, but I think the commissioners who are interested in proving your suitability. So this is the opportunity we give you also to engage us.
Thank you, Chair. I just want to say thank you very much for finding me deserving to be shortlisted, for the opportunity to appear before you, and for the courtesy you have extended to me in the questions asked. I want to say thank you very much and wish you well also in the process of doing the evaluation and determining the suitable candidate. Thank you very much, everybody.
Okay.
Yes.
On behalf of the commissioners, we also wish you well, and we wish you success in all your endeavors. We will get in touch with you when we complete the exercise.
Thank you very much.
Yes,
thank you.
We are now releasing you.
Yes.
Good afternoon, Judge. My name is Charity Kisotu, a commissioner. You are welcome.
Thank you very much.
Good afternoon, Judge. Omwanza Mbati, karibu.
Thank you and good afternoon.
Good afternoon. I'm Joaquin Dongo, representative of the Supreme Court on the Commission.
Thank you.
Good afternoon, Judge.
Good afternoon, my
Anthony Mrima. Welcome, and I wish you the best.
Thank you very much.
Good afternoon, Justice Kigen.
Good afternoon.
Fatuma Sichale, I'm your representative at the Commission. Karibu sana.
Thank you very much.
Good afternoon, Judge.
Good afternoon.
You're welcome. My name is Oluwande Evelyn.
Thank you.
Good afternoon, Judge. Dorcas Odor, Senior Counsel and Attorney General. Welcome.
Thank you very much, Commissioners. Judge Joseph Kipchumba Kigen Katwa.
Yes, my lady.
Could you tell us your county and your ethnicity?
My county is Elgeyo Marakwet and my ethnicity is Keyo.
Very well. Do you know why we ask that intrusive question?
I do, my lady.
Why?
I think for regional balancing and, basically regional balancing, I think.
Is it a constitutional imperative?
Yes.
Which particular article?
I can't quite place my finger on the exact article, but I would say it is intended by Article 10, Article 7283, and Article 236.
Yes, very well. So now we will start. You were here not long ago, and I think the challenges I have is what questions to ask you, because we recently interviewed you successfully for the judge of the Court of Appeal, and you have hardly been there for 3 months. You under normal human HR practice, human resource practice, at least one stays in a job for 6 months to be evaluated for promotion. You haven't been there for even 6 months for promotion. So maybe you can explain this before we go to the questions.
Yes, my lady. I know that you very particularly mentioned the point that I haven't been there for more than 3 months, and that in an ideal environment I should have waited for a little more time so that there is perimeters for my evaluation for promotion. My lady and commissioners, my understanding of why I am here is different from that. My understanding is that I've come here for evaluation as to whether or not I'm eligible for appointment to the Supreme Court, and that eligibility is not a question of promotion, it's a question of whether I'm qualified. And when I looked at the scoping that was done for a person who can qualify for that office, I thought I met the conditions, and in the circumstances I applied. So, Chair and Commissioners, I'm here very humbly seeking that I be evaluated on my competence to be appointed. And the fact that I may have recently been before you should not be a factor, because I'm not here for a promotion. I'm here for whether I'm competent. I also observed that quite a number of people have come to the Supreme Court directly from outside judiciary. And so judiciary is not necessarily a stepping stone for qualification to qualify for that office. Those are the considerations that were in my mind, Chair and Commissioners. And I say this with the greatest humility.
Mm-hmm. Very well. Now, then we can come back and forth to that question of, are you happy in the Court of Appeal? Are you satisfied with being a judge in the Court of Appeal?
I am, my lady and commissioners, and thank you very much for having found me deserving to take up that office. I want to express my gratitude to all of you.
Mm-hmm.
Yes.
Yes. So now, we want to hear from you why you think this commission should recommend you for nomination of the office of a judge of the Supreme Court. We want to hear what experiences and skills and knowledge you will bring to this court, and how you're going to leverage them or to locate these skills within the 5 or so jurisdictions of the Supreme Court.
Thank you, Chair and Commissioners. I consider myself eligible for consideration to the office of Supreme Court Judge on the premises that, in my estimation, I have a feel and experience of all facets of Kenyan, both as a Kenyan citizen and also my competence in legal practice. I grew up in an environment of want. I went to Kiplombe Primary School. I went to Mother of Apostles Seminary. I then went to St. Patrick's High School, then came to Nairobi University. And through all those levels, it was hard work, enterprise, and studies that took me through all that. I then entered into legal profession now for about 30 years. And I have both national and international experiences. I have represented all cadres of people. I have gone to all legal forums and even non-legal forums. And the wealth of all those experiences, my lady and commissioners, are such that I would contend that makes me very qualified for this. A little more on the issues of where I've appeared. I appeared in tribunals, I appeared before commissions, I appeared before magistrates all the way to the Supreme Court. I have represented judges, I have represented advocates, I have represented other people. I mentioned particularly representing advocates and judges just to make the point that those are the best judges of my competence, and if in their evaluation they thought I could represent them, then it is a strong statement of my competence. I think the type of works I have done, the results I have produced, are such that they also strongly comment on my competence. I will not pretend to know all the law, both in terms of statutes or precedents. I will not pretend. But what I can say for a fact is that I have the competence to identify what the issues are, to be able to analyze them, to be able to research and familiarize myself with what I need to determine. And this is born out of experience. I have represented people outside the country where I've had to learn other legal regimes and systems, and particularly the confluence of common law and civil law at the ICC. I have had to study and analyze the operations of sports law and represented athletes in on sports law. And the legal regime, I appeared even long before the legal statutes were quite in place in Kenya. And so there was near vacuum on what we need to look out for. And it was through my research and enterprise that I was able to familiarize myself and be able to represent them. I have also appeared in the East African Court in Arusha, and that required of me to look beyond the statutes that apply in Kenya, to look at the statutes that apply in East Africa and internationally. And the accumulation of all those experiences, my lady and commissioners, are such that I contend that I'm in a position to be of service to the judiciary at the level of the Supreme Court.
Thank you very much. We will now move on to another area, and Justice Shale will take it from here.
Thank you, Honorable Chief Justice. Judge Kigen, there are concerns expressed by a section of Kenyans.
Yes.
As regards your suitability for the position of a Supreme Court judge.
Yes.
And these concerns were made known to us as the Judicial Service Commission via a letter dated 8th of April 2026, which we have since brought it to your attention. Did you get that letter?
No.
Oh, I'm sorry.
No, I'm hearing it for the first time. But I suspect I know what it could say. Probably just say it.
Okay. Let me just bring to your attention what the section of Kenyans are saying. They're expressing their misgivings about your candidature. Firstly, they are concerned over the fact that you've been a lawyer for His Excellency President William Ruto, and who is likely to be a candidate in the elections of 2027. The fear that these Kenyans have is that in the event that you're successful and you join the 6 judges in the Supreme Court, and then thereafter there is a petition challenging presidential elections for the year 2027, their fear is that you are likely not to be impartial. What do you have to say to this?
Okay, so first of all, it is true I have represented him. May I say that I intend to be as objective and neutral in my discharge of my functions as a judge. And so the fear is, well, I can't say it is ill-informed. I can understand the concerns, but I just want to give the assurance that I would be fair and I would only deal with facts and the law. I would also like to say 2 other things, commissioners. The first one is I am aware that that concern has been, and that's why I was saying I have suspicions that of what the letter is, and I must complain that you didn't share the letter with me so that I would have a more structured answer to the question. But let me just answer to this effect. That I have looked at the totality of judges, right from the High Court, Court of Appeal to Supreme Court. Looking at the totality of them, you would almost say about 50% of them were lawyers. And so for me to be told that you have a disadvantage because you represented a particular individual would be a borderline case of discrimination, because I would be being treated differently just because of the type of the client I represented, when in fact every other person who escalated to the status of a judge who was an advocate is not being subjected to the same disadvantage. And so, commissioners, with a lot of humility, I would pray that first of all, you look at me for what I stand for, integrity, fairness, and justice, and that I will apply the law fairly and objectively. But secondly, that to distinguish me just because of one client, a criteria that has not been applied to other candidates who applied to be judges, would probably not be quite fair. And lastly is that there are measures, if anybody is concerned about my sitting in the bench and as justifiable cause, there are provisions for how that can be handled, including recusal, and I'm aware that some presidential petitions have been done with less than the totality of the 7 Supreme Court judges. And the Supreme Court's workload is not focused or limited to only presidential petition. There are other work assignments that the Supreme Court has. And so if it were to be such a significant and weighty concern, I would say there is that option also for recusal. For all those reasons, commissioners, I pray that that should not be used to my disadvantage in this interview. I am glad to answer any specific issues that arise around that issue.
All right. I think we hear what you are saying.
Yes.
But you know, when it comes to the dispensation of justice, it is not important. It's not only important for justice to be done, but justice must also be seen to be done. And given the fact of the office in question, the stakes are extremely very high. And when you tell us, for instance, that there is that possibility that you can recuse yourself, and given that the number is only 7, and you know there are many things that happen in life, people fall sick, etc., etc. So if now we are saying we are going to take you, and then you've given us that undertaking that in the event that there is an objection to your hearing an election petition, presidential election petition, there is that possibility that you can recuse yourself. So what does that mean? That then, do we really even need to hire a 7th judge for the court? If we have the option of a recusal, right from the word go.
Can I proceed?
Pardon?
I can answer now.
Yes, please.
Okay. So, recusal is probably the bottom in the list, my lady. I would insist that I should be taken for what I say and what I have represented, being objective. My relationship with His Excellency is not such that I always said yes to everything he wanted or he wished for. And so it has never taken my objectivity away. But I understand your question to be more of the perception of third parties. So again, I want to say that the front line is to say that I should be taken for what I represent, that I intend to be objective and fair, and that issue of recusal should be the last option. And even as I'm being put to task to answer that, I also want to insist that please take on board also the unfairness of the question and the unfairness of the concern just because of the person that I represented, a criteria that is not applied to other candidates.
All right. We just thought that it was important to bring to your attention what a section of the Kenyans are saying about your candidature.
I understand.
And you've given us your responses.
Yes.
The other concern, of course, was the fact that you've hardly been in the Court of Appeal, But I think you've discussed that in response to what the Chief Justice asked you. So now to my technical question. In a book entitled Cases That Changed Our Lives by one Ian McDougall, and in a scholarly article in that book, the scholar marvels at the wonders of the law, and I want to quote what he says. Who would have ever thought that a partially decomposed snail in a ginger beer bottle would change the course of English legal history? I'm sure you're aware of this case. A snail in a ginger beer bottle.
It doesn't come to mind immediately, my lady.
Wow. Because then my next question was going to be,
yes,
how did this case change the course of legal history in the countries that practice common law? Don't know you versus Stevenson?
Oh yeah, of course I know you versus Stevenson.
Yes. What was the law before the snail?
I know the law that was developed in that case being that whoever keeps an item that causes damage to injury to somebody else is responsible for the damage that follows.
I asked the question, what was the law before the snail, keeping in mind the doctrine of the privity of contract. And if I may just remind you about the facts of that case, is that two ladies went to a cafe. One bought the two drinks, but Mrs. Donoghue was not the one who paid for the drink, and a snail was discovered in the bottle. And then the big question was, could she sue, and yet there was no privity of contract? She's not the one who had purchased the ginger ale. Are we together?
Yes.
Yes. So what was the law before then, and what is the law now?
My understanding of, okay, I can't say for a fact I know what the law was previously, but I suppose considering what the law then developed in that case must have been that it is a condition for you to claim damages that there is a privity of contract, that you have to have a relationship with the person you are suing. But then the consequence of that case was that if you are offering a product, it should be probably in more developed law now, consumer rights. If your items cause damage or injury to somebody else, the fact of lack of privity of contract is not a defense to your liability for what you're offering to third parties.
So that is a law after 1928, but before 1928, you had to establish that there was privity of contract. Now, coming back home to the Supreme Court, what are some of the notable jurisprudential decisions that you can say have impacted our lives?
How many, my lady?
Pardon?
How many?
Give me 4.
Okay. So I think the most remarkable ones for me are 2. The first one is BBI, and the issues then were whether, in the name of amendment, the executive could torpedo the Constitution, could replace the Constitution in the name of amendment. And I thought judiciary came out very proudly there to firmly put down their foot and say, we can only change the Constitution using what is there. And I thought that was a very momentous.
So that is one.
Yes,
one.
2.
Yes.
Is the 2017 elections, August 2017 elections, where the judiciary distinguished itself in refusing to recognize the presidential elections. I did not and do not agree with the reasoning of the court then, but I thought even then we shouldn't miss the point of the independence of the judiciary in making that decision. I thought it was a very momentous and strong statement of the independence of judiciary.
I agree with you.
Yes.
Number three.
The third one from the Supreme Court would be the finance bill. For quite some time, I know there has been pull and push between the executive and judiciary, and it entails questions of whether the judiciary is being activist, is overreaching, and is micromanaging the executive. The concept developed in that finance bill, suspension of declaration of invalidity, is a very important measure, because then it gives the executive time to adjust itself to the requirements of the circumstances of the situation.
All right. And finally, the fourth one?
The fourth one is the Muruwatetu one. Of course, it is very controversial, but then the determination that there has to be a distinction between the roles of the executive and the judiciary and the executive, the separation of powers, was to me a very important.
Was that in Muruwatetu 1 or Muruwatetu 2?
In actually both, because in one, the decision I thought was a general statement that the judiciary should not seem to determine the sentence.
All right.
Should not tie it. But then in the Muruwatetu 2, then the Supreme Court came back and said our intention was only limited to murder.
All right.
I think, yeah.
So it is like the issue of discretion, mandatory sentences.
Yes.
The executive should not interfere, but it should be left to the judiciary. Yes. Thank you. That's all, Honorable Chief Justice.
Thank you, Commissioner Mwansa.
Thank you, CJ. Good afternoon, Judge, again.
Good afternoon, Commissioner.
Judge, Article 19 of the Constitution is the article that starts with the rights and fundamental freedoms.
I'm allowed to refer?
Yes. And now, Article 19.3 provides that the rights and fundamental freedoms in the Bill of Rights belong to each individual and are not granted by the state. Then Article 19.3b provides that the rights and fundamental freedoms in the Bill of Rights do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are inconsistent with the chapter. And 3 provides that those rights are subject only to the limitations contemplated by the Constitution. Now, in developing that issue, we have what we call enumerated and unenumerated rights. And it could seem that what Article 19.3b states or provides for are what we would refer to as unenumerated rights. Now, while enumerated rights are clearly written, the unenumerated ones are inferred. So that the concept is that there is a limited list of rights in a constitution that does not mean that fundamental rights do not exist. So the first question is as follows. Are there rights that you would say that are fundamental and are not contained in Chapter 4 of the Bill of Rights, but they are unenumerated and you can infer them? And if so, if you probably can list maybe 4 or 5.
Okay. Commissioner, I'm not sure I know I have an answer to the point you made about the enumeration. I'm not aware whether there is anywhere where they are listed, other than in the Constitution, of course, which I'm aware of. But I don't know whether they are somewhere else tabulated. Commissioners, I will pray to probably refer to the experiences I have. Some of the rights that I know are internationally recognized but are not captured in the Constitution is, for instance, against genocide. I am fairly sure it is not in the Constitution in the words genocide. I know there are issues of human dignity, human rights, against servitude and all that. But I think genocide as a crime is not there, and I'm borrowing from the International Criminal, the ICC statute. And I'm referring to the ICC Act because Kenya is a signatory, which in effect then, and most of the world countries are signatories, which then means it is a recognized right. So genocide, war crimes, acts of aggression. Others that come to my mind, and they do not necessarily even relate to Kenya, is apartheid. I think there is generally condemnation of conduct that amounts to apartheid, and I think that could be one of the rights that you could incorporate there. The upheavals in West Africa resulted also in warrants and summons on issues of damage to World Heritage Sites. And so I think UNESCO protected locations, or rather damage to World Heritage locations are also a crime. Commissioner, I hope I've managed to make 5. I'm not sure if I have.
Okay. Now I want to go to Article 45 just to explore that topic.
Yes.
So Article 45 of the Constitution provides that the family is the natural and fundamental unit of the society and the necessary basis of social order, and shall enjoy the recognition and protection of the state. And more importantly, Article 45(2) provides that every adult has a right to marry a person of the opposite sex on free consent of the parties. Now, when you read Article 27 on equality and freedom from discrimination, this is now the equality clause. It provides that every person is equal before the law and has a right and equal protection and equal benefit of the law. And then there is another important article. 27(4) provides that the state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, health status, ethnic or social origin, color, age, disability, religion, belief, culture, dress, or language. Now, this article in the first draft of the Constitution actually provided for discrimination against sexual orientation, but subsequently in the discussions that followed and the final draft excluded that reference. Now, if again you read Article 2(6) of the Constitution, it provides that any treaty or convention ratified by Kenya shall form part of Kenyan law under this Constitution. So I wanted to ask a question using that context. Now, Article 16 of CEDAW, the Convention Against Discrimination of Women, provides that a woman has a right to choose their partner. And the definition in Article 16 of CEDAW is different from the one that is found in 45. So the question is, if a party comes to court and pursues an argument that that article would allow maybe a same-sex marriage because it's a convention that forms part of Kenyan law, what would your view be about it? And would that be then what we started developing about an unenumerated right?
I can answer?
Yes.
Okay. So first of all, let me just add one more in the list I had given. I've just remembered in the course of you inviting me to Article 45, I have remembered that Kenya now acknowledges for a fact that intersex people are entitled to rights.
Yes.
And that's not one of the rights of intersex and transgender. And I thought, even to the extent it is not enumerated, it is a consideration. I'm just concerned at what it says in 19.3b that to the extent that it is not inconsistent with this chapter 4. Now, just on that issue of transgender and intersex, still, I have sometimes wondered whether the Supreme Court should be asked to determine whether the Constitution on its face, looking at it on its face, is wrong. Because at 45.2, I haven't answered your question, I know, but I'm just laying the ground.
Yes.
45.2 says every adult has the right to marry a person of the opposite sex. Now, what happens to the transgender and intersex people in Kenya whose existence we have acknowledged? Have they in effect been excluded by the Constitution? And probably more pointedly, and I think now this comes to the question you're asking me, is if two intersex or two transgender people come and say they want to marry, and the courts have determined that they are entitled to rights, are they then to be denied the right to marry using Article 45.2? And could it be that the drafters of the Constitution then were mistaken in the wording they have used in 2 because they have in effect discriminated? And further still, whether then the Constitution on its face is wrong and discriminatory. Now, to the question you've asked whether what I would do if I had two same-sex individuals seeking permission to get married to each other. To the extent to which there exists that clause 45.2 saying the limit of people who can marry each other of opposite sex, I would say it is not possible. However, Commissioner, it is an issue I've looked at because I had, in my previous life, I had been asked to consider an argument on this. I have sometimes wondered, Commissioners, whether Article 45 can be read to represent two scenarios. The first scenario is that one limited only to paragraph 45.2, being two adults needing to marry, in contradistinction from a situation where the heading of that Article 45 is headed family. And then one says family is the natural and fundamental unit of society. Whether it is possible to deny permission for marriage, but the Constitution inherently acknowledges that you can have a family of same sex. That would be my contention, that for purposes of marriage, probably as a judge, I would say the law is clearly prohibitive. But then I would wonder then whether the law seemingly at clause 40, so the only exclusion is 45.2. 45.1, 1 and 3 and 4 seem to accommodate existence of a family. And so if it is possible to argue that there is a difference between a marriage and a family, then it should be possible also to say that there is almost a permissive extent to which the Constitution allows a family constituted of people of same gender. Of course, I'm very much alive that I am a candidate. I know it's a very unpopular argument, but I'm just making it as a legal argument. I'm not making it as a question of my position. I need to clarify that. The second limb of your question was whether then you could say that Article 16 of the Convention on Women's Rights, I am not very familiar with that convention, whether that Article 16 is one of those unenumerated rights. I think the Article 19 that you had invited me to was very explicit that they are tenable to the extent to which they are not inconsistent with the Constitution. So if the question was whether or not they can get married, I would say it is not one of those rights that are protected. But if the argument is that we want to be recognized as a family, then I think the matrix of the issue would be completely different. Probably then there would be an argument around it, Commissioner.
Okay.
The question was very long. I have tried as much as possible to answer it. I don't know if I've answered it.
Yes. So I try to set the context because there are sometimes there are hard questions that are presented before the court and that the court should answer. Now I want you to take to Article 49 on freedom and security of a person.
Yes.
So Article 49 provides that every person has the right to freedom and security of the person, which includes the right not to be, and for purposes of my question is D, subjected to torture in any manner, whether physical or psychological. So physical torture is fairly, something, it's discernible.
Yes.
But psychological torture might not be, immediately discernible. So you have, and this possibly we practice it when we were younger, where we were, as children, we did not have a choice to the oath of allegiance. I pledge my allegiance to the President and the Republic of Kenya. You remember that?
Yes.
Or salutation of the flag.
Yes.
Now, would you say that forcing children, to do oaths of allegiance or to salute to the flag, without having the choice on participating in those activities, would amount to being subjected to torture, whether physical or psychological? Because it's not a choice that you have, particularly if you're in school. I don't know whether it happens right now, where you are told, salute to the flag, or it's at 6 p.m. the flag is about to be lowered. Stand up and be at attention, or do the loyalty pledge.
Okay, so can I answer?
Yes.
Yes, my answer would be, I understand your question to be particularly in respect to the flag. You didn't say what flag, but I assume it would be the national flag.
Yes.
You also said pledge. I assume it is pledged to the country rather than to an individual or to any religion. To the extent, therefore, that you are dealing with national symbols and national concern, I would think it is more of patriotism than a question of torture. That's one. Number two, I would say, since your question is very carefully cross-referenced with children, that children being people who are being molded, it is right that they should be subjected to develop a sense of patriotism and loyalty, and I wouldn't see anything wrong in subjecting the children to appreciate the importance of patriotism and loyalty as they grow. And lastly, you tie your question with the question of torture, both physical and psychological. My understanding would be that torture is a relevant part if you intend to extract something out of it. In the situation of the children, I think it's just teaching them where priority, where importance, where values exist. It wouldn't seem to me like anything is being extorted out of the children. They are not being asked to make any confession. They are not being asked to sign off any rights. They are not being asked to surrender anything or to give anything. And to the extent, therefore, that it is part of education and development of the children, I would contend that it is a legitimate conduct.
Okay. And lastly, if you look at Section 3 of the Supreme Court Act, provides for the object of the Act and makes further provisions with respect to the operation of the Supreme Court and its final judicial authority. And one of the guiding principles under 3 is that the court should develop rich jurisprudence that respects Kenyan history, traditions, and facilitates its socio-economic and political growth. Are you aware of instances whereby either the Supreme Court has developed the common law, or it has infused these constitutional principles and created sort of a Kenyan context interpretation of the law? And I get this from what Justice Mutunga used to say, that we should develop jurisprudence that is indigenous.
Okay, so I will answer the question in terms of what indigenous jurisprudence and principles of law have been developed by Kenya, and with reference to your question, particularly by the Supreme Court. I think in the recent past, the Supreme Court has made a determination on the question of matrimonial property. And in it, I think it is an indigenous contention that contribution for purposes of the rights of a spouse can be gauged, not limitedly to financial contribution. It could very well be in kind, family upkeep, taking care of the children, and I think that's an indigenous contention that contribution is not limited to financial contribution. I think that one. The other one, although I can't say for us absolutely that it is, it has been determined by the Supreme Court, I think is the issue of trust on land, being that where you have a family member being registered in the course of adjudication and other types of registration, being registered as the owner of the land, it shouldn't be perceived as if that is the only owner of the land. It should be treated as a trust on behalf of the family, on behalf of the other family members, and that it is being held by the person whose name is registered in trust for the rest. The other one is probably also trust in relation to matrimonial property. That where you have one spouse's name being registered in the
Thank you.
Example, or for instance, there is a pervasive understanding of what constitutes public interest, and rarely do courts differ on what constitutes public interest. But we cannot say the same of general public importance. So as you answer, you may kindly also tell us whether there is a difference between public interest and general public importance, and whether or not there is a need for jurisprudential coherence and guidance on the same.
As usual, AG asking me the toughest question. So let me start first of all by saying I would have thought the Supreme Court, because it has reiterated this, I know every other person wants a chance at the Supreme Court, and so there have been so many applications to the Supreme Court. And I think the Supreme Court has been very consistent in saying that for general public importance, the criteria is number one, that the issue you are seeking the court's attention for should transcend your personal dispute and should be a novel issue that needs resolution and will be used by other parties. And thirdly, that it should have escalated from the courts below to the point of the Supreme Court for determination, that you do not jump onto the Supreme Court and ask them for a determination when it has not graduated and escalated through the courts below. Now, you are then, I also wondered whether your question was also whether the court has settled jurisprudence on whether they can consider interlocutory applications. And my reading of it is that initially the Supreme Court had said we will not deal with any interlocutory application. We will only determine when it has yielded a judgment. But then with time, they have put some riders where they have allowed interlocutory applications even when the substantive hearing has not been determined. Now, on the specific question of public interest and public importance, that was the question, Honorable AG. Public interest and public importance.
Whether there is a difference in definition or understanding.
I would contend that public interest and public importance is one and the same thing, especially for purposes of the determination of the question for the Supreme Court of a matter of general public importance, because it would be both in the interest of the public and of importance to the public. Whichever question they have to wrestle with would be one that has been distilled as being one that the public is interested in and is very important for the public. I know the concurrent argument between the competition between public interest and I think national interest, but that's not your question. But I would say, in answer to your question directly, for purposes of Supreme Court's jurisdiction on a matter of general public importance, I think I would deem and consider any matter that is of public interest and public importance to be one and the same for purposes of the court's consideration. And I would say the court has obligation to consider them, whether it amounts to being a matter of public interest or it amounts to a matter of public importance.
Okay, and finally,
yes.
Do you think there are instances or cases where the Supreme Court has made a mistake? And if so, would they have done anything better? If you can identify one or two. I'm not saying they have. I'm asking you whether you think there are cases where they have made a mistake, and if so, would they have done better?
Okay. It is an unfair question because I am a candidate, but let me answer it all the same. Murwatetu 1, I think, could have been done differently. Because Murwatetu 1 would seem to have just made a general proposition that the legislature should not spill into tying the hands of the judiciary, a judicial officer. And that in consequence then has caused the need to rush into clarifying. So Murwatetu 1 probably would have been done a little, would have been adjusted a little more. This we need to have access to the agreement between Kenya government and Chinese government to be looked at and to be evaluated and to be audited. When the Supreme Court said that we are declining and avoiding dealing with it because the courts is that my rights have been violated, and so should I be compensated? But instead, the decision that came out was, no, you cannot take us to East African Court of Justice to.
Thank you. Maybe just a follow-up question on Murwatetu.
But may I say also, Honorable Attorney General, this is the second time you're asking me that question, because the last time you asked me whether the East African Court of Justice can decide on matters.
Supreme Court position, which I totally agree with. Now, the certification, if you look at Article 1634B, is to be done by two courts, either the Court of Appeal or the Supreme Court. If it's done by the Court of Appeal, it can be reviewed by the Supreme Court. I believe this provision was made on the premise that these matters of general public importance will only emanate from the Court of Appeal, being the highest appellate court by that time.
Thank you, my lord. I think from my reading, the Supreme Court has clearly said you cannot leapfrog directly to the Supreme Court, so you really just have to go through the door of the Court of Appeal, unless a statute, because I know there is the argument that some tribunals can go directly to Supreme Court, but in a normal litigation, then you can't enter the Supreme Court without passing through the Court of Appeal. I wasn't sure I got your question because you started by saying small claims court, and I saw you almost said MCS also, because I think also MCS enter the High Court. They can't go beyond there. And the question you're asking is where there are conflicting decisions, whether they should go to the Supreme Court. And just for clarification, very kindly, Commissioner, are you limiting your question to the conflicting decisions in small claims issues, or generally on issues that cannot escalate beyond High Court?
Let's be general.
Okay.
I brought in the issue of small claims as an example.
Okay.
But it's a general question.
Thank you very much. Yeah, of course, the other example would be the MCS. This is the way I would answer, my lord, that I would think the Supreme Court would have jurisdiction if there is a genuine matter of general public importance in any of those issues, being a real identifiable issue that they need to resolve rather than a question of merits. And if it were to be the case, as you say, that there is concern that there is strangling of some causes not to go beyond High Court, I would see a petition being framed to cover, including the concern you have, that one, either the question arising from small claims courts is this, it is a matter of general public importance, or this issue in the MCS elections is of general public importance, and ask the High Court to determine whether they are substantive enough and to apply their minds. So there would be then a determination on two things. One is that it is so grave, it is of such a public importance that it warrants the consideration by the High Court. And if the High Court cannot, and if the court determines it and one of the parties is aggrieved, then leave as a matter of constitutional right to escalate it to the Court of Appeal and to Supreme Court. So that then for me it's a question of how it is framed. It needs all the issues just need to be placed on the table, and they need to show gravity on the face of it. Because I would see if it is a question of small claims, it doesn't matter that it is it doesn't matter that it is a matter of small claims. It doesn't matter that the policy for small claims is finality of litigation. What matters is that if there emerges a very significant point that needs consideration by courts, and then it can, I think it could still escalate, depending on how it is framed.
Now, Judge, if I get you right for clarity,
yes.
Do I get it that you maintain that such an issue, even after you are satisfied that is an important question which needs consideration by the SCOC, you will give more credit to the process and maintain that you can only frog from High Court to the Court of Appeal to the Supreme Court? Will you be looking at the process more than the substance of what? Because that may go contra 159 article.
Okay, first of all, let me just answer your question directly, my lord, that I insist you cannot leapfrog. And the reason why it is necessary not to leapfrog is because it needs consideration by the Supreme Court after the other courts have considered it. You can't fly it over to the Supreme Court before the other courts have considered and applied their minds and possibly resolved it.
Yes, so sorry for engaging you. I agree,
yes.
But this is a matter which does not need any clarification, any further clarification. The Supreme Court has already said if there is an issue of conflicting decisions, that's a matter of GPI. The issue is settled, it's clear. It's just a matter of taking it from the High Court to the Supreme Court and say, this is one of those you say.
Yes, my lord, but I think there are still some cures. For instance, if there are conflicting decisions, and that happened in the issue of statutory notices, they had to set up a special panel right from the High Court to the Court of Appeal before then it go to the Supreme Court. Okay, at that time there was no Supreme Court. Before it would go to the Court of Appeal, the issue of, the other one was the issue of arbitration. So that it is not good enough to just say, one High Court judge says this, the other High Court judge says this, so there is conflicting, let's rush. Or that one bench of the Court of Appeal says this, the other one. I think there is still that aspect of saying, let's now constitute a bench of, say, 5 or 7 judges, either the High Court or the Court of Appeal, to give it a thought before it gets to the Supreme Court. I still insist, my lord, that even in terms of policy, it would be disadvantageous if somebody just walks to the door of the Supreme Court and says, I have these two decisions, please decide for me, before it escalates. So if you have a bench which has been decided by 333 in Court of Appeal, and you constitute a bench of, say, 7 or 9, the likelihood is that the assembly of
do you think, Judge,
yes,
that there's a difference between general elections, fresh elections, and a runoff?
General election, fresh elections, and
a runoff.
Runoff.
Yes.
Okay, so runoff would be a situation where nobody garners 50+1 in a presidential election, in which case then the top 2 candidates would go into runoff. General elections is the standard cycle of 5 years elections, and fresh elections is where elections have been nullified and parties have to go back, or rather a constituent entity, either county or constituency, needs to go through another election.
That's very right, Judge. Now, I want us to consider an issue. I believe it has not arisen yet, but it can arise. And let's take a walk to a fresh election. And let's start from a point where a petition challenging a presidential election is filed in the Supreme Court. The position which has been taken by the Supreme Court is that in the event a fresh election is called or ordered, it is only the petitioner and the president-elect who should take part in that fresh election. We are together, so that end, Judge?
Yes.
Yes. Now, let us take it this way. A petition is filed before the Supreme Court challenging the election of a president. And a candidate, an unsuccessful candidate, decides not to file a petition, that with the leave of the Supreme Court, this candidate is allowed to join in these proceedings, in this petition, as an interested party. An interested party has identifiable stake in this matter and has the right to file pleadings.
Yes.
And in these candidates' pleadings, it's stated very, very clearly that I'm in total support of this petition. The election has to be nullified, and once nullified, I am interested to take part in the fresh election. So, the position of this candidate is clear, that I want to take part. He has not acquiesced his or her position in that. He has stated very, very clearly in pleadings that if it is the petition succeeds, I also want to run. But the jurisprudence which has been developed as a term is that it is only the president-elect and the petitioner. And the reasoning has been the rest of the candidates, as long as they have not shown any interest, they should not take part, which I agree. But this is a situation whereby this party who has been allowed by the court to come in as an interested party has expressly stated that its intention to run, and eventually the election is nullified and a fresh one called. Will this interested party be able to take part in that fresh election?
Thank you, my lord, for the question. We need to, okay, so your question as is the nature of always illustrative scenarios. Yeah. The question doesn't come out as to whether the petitioner is a candidate, but I want to,
the petitioner must be
and it is easier for me to answer the question if you don't, I don't have an answer to that question, because then we would then be looking at it and saying, what if the petitioner was not even a candidate, he's just a public interested litigant, and you are declaring that parties must go back for fresh elections. There has to be other candidates. So I would say in the scenario you've made, the candidates, so long as a person was a candidate in the elections leading to the nullification, they are eligible to participate, unless there is a specific reason why not.
Let me get to
Yes.
that, Judge.
Yes, sir.
You're saying in a fresh election,
Yes.
all candidates are eligible to take part. If I get you right, that's your position.
It depends on the nature of...
No, I limited myself
Yes.
to the position taken by the Supreme Court,
Yes.
which is a case premised on the petitioner being a candidate.
Okay.
And the court said it is only the candidate who is the petitioner and the president-elect. But now I've introduced a further element of the interested party.
Yes.
And the reason why the Supreme Court says the other candidates should not participate is they have not taken any active step in expressing their desire to run in the fresh election.
Yeah.
But this is an interested party who has said, I'm interested. I filed my paper, I support this petition. And if it goes through and a fresh election is called, I'm interested to run. So they cannot be said to have exercised their position. They have stated clearly that I need to take part in the fresh.
My Lord, I would think that if an interested party has come and said, because an interested party, first of all, is one who has a stake and will be affected by the decision.
Yes.
If he is a significant player and it's obvious that he's a significant player because from your illustration he was a candidate,
yes,
then it is my view that he is eligible to participate in the elections. Because look at a scenario where you have 5 presidential candidates, and when you cascade votes, probably the one who has come to court was the one who got the least votes. And the Supreme Court then says the people who are going to participate are only the petitioner and the president-elect. It would be just unreasonable. It would be awkward. So I would say if somebody has come and explained himself why he did not petition, what his stakes are, what he considers to be his rights, and considering that it is a question of democracy and representation, I would take the view that an interested party who has made that expression should be allowed to participate in the elections. And I'm comforted by the fact that the point you are making has not been quite directly dealt with, being the question of whether an interested party who comes and says, I want to participate, my explanation for not having filed the petition is this, these are my stakes. To the extent that it hasn't been addressed, and being an open question, I would say my view is that if he should be allowed to participate because he has come and represented his concerns, and if he can demonstrate his case, then he should be allowed to participate.
Thank you so much.
Thank you too, my Lord.
I believe that should be the position. Looking at the issue of access to justice, limiting costs, and many other parameters. Thank you for this rather long engagement. I wish you the best.
Thank you very much,
Thank you, Commissioner Ngutia.
Thank you, Chair. Good afternoon once again, my Lord.
Good afternoon.
It's been a long day so far.
It's okay. It's okay.
Yeah, they say Kenyans know the Supreme Court to be the court that only deals with presidential petitions. So I understand why Judge Murima had to take a lot of that time. So, Judge, you did submit submissions that you have handled at the Supreme Court and High Court on matters touching land, criminal case, arbitral award, and a constitutional petition appeal, and also shared a no case to answer motion filed before the International Criminal Court. The exhibit excellent issue identification, coupled with strong ability to link facts to applicable legal principles. And looking at the ICC matter, where you submitted on the need for clarification on application of the no case to answer principle within the ICC framework vis-a-vis common law jurisdiction, I find the arguments novel, so I commend you. Have you since delivered any decision at the Court of Appeal or decisions?
Yes, I have.
Okay. I know my colleague will ask you around that. So allow me to ask you 2 questions.
Yes.
Of elections, because the Supreme Court does so many other things beside the elections which Kenyans are usually keen on. Key strength in arbitration is finality, and that is why you find most laws on arbitration clearly provide for this fundamental principle. In the New to Aggravate case, the Supreme Court was confronted with what is described as question of considerable public importance touching on the interface between arbitration and the appellate jurisdiction of the superior courts in Kenya. So what the court held is that Section 35 of the Arbitration Act is silent on whether
an appeal should lie to the Court of Appeal, and this is what it held in part. Allow me to read. An appeal may be allowed in very limited circumstances where a manifestly strong decision was made, specifically where the High Court, in setting aside an arbitral award, has stepped outside the grounds set out in Section 35 of the Act and thereby made a decision so grave, so manifestly wrong, and which has completely closed the door of justice to either of the parties. So how would you describe the reasoning of the court by creating this exceptional circumstance vis-a-vis the general principle of finality in arbitration? Was the court trying to cure any lacuna in the Arbitration Act, or did it risk undermining the fundamental principle on limited court intervention in arbitration? Maybe you can give your explanation to your responses.
Thank you, Commissioner. Yes, indeed, in that case of Mu 2, my recollection of reading it is that one of the issues the court had, so the court was dealing with about 4 issues. The first one was whether the court can infer existence of an option to appeal when, I think it is Section 35, is silent, on whether a party who has gone to court for adoption of an award can appeal to the Court of Appeal. And so the question was just very directly whether, in the absence of clarity, in the absence of a direct statement on whether or not there is right of appeal or not, the Supreme Court thought that such an option to appeal could obtain. And reading that judgment, my understanding was that then the court was wrestling with a competition between 2 issues. One is the right of any litigant to a fair hearing, which is a constitutional right, and on the one hand, by the party who wants to appeal. The one party who wants to appeal saying, my rights to fair hearing have been violated, I need an opportunity to ventilate my case. Vis-a-vis the counter-arguments from the other side saying that the policy and intention of arbitration clause is to achieve finality and sooner resolution of disputes. And in some, my understanding of how the Supreme Court arrived at its decision is to balance those 2 rights. One is the right to be heard and right to challenge a situation where the decision of the High Court is so manifestly wrong on its face, vis-a-vis the desired intention of the 2 parties that there should be finality. And as a consequence of balancing those 2 interests, then the Supreme Court said that you will only appeal to the Court of Appeal where you are able to demonstrate that your situation is very distinct. It's not just the usual issues of disagreements or dissatisfaction or ordinary displeasure. You have to distinguish a very remarkable dissatisfaction with the way the High Court has dealt with the adoption of the award. And so that's why it is restricted, and that's why, to my mind, it requires leave, because that leave stage is where the court then will see if, will evaluate whether it is an ordinary displeasure or it has a very distinct legal or factual issue.
So according to it, does not in any way undermine the statutory design of that particular provision?
It doesn't undermine, and it prioritizes fair hearing and justice to all parties.
Okay, I'm satisfied with that response. And number 2, the case of Mitubel Welfare Society versus Kenya Airports Authority. I know you know the facts. But what the court held is that structural interdicts are recognized reliefs in human rights litigation, and Article 23(3), sub-Article 3 of the Constitution, particularly when it comes to enforcement of social economic rights such as housing. In this particular matter, the Court of First Instance had issued structural interdicts. The Court of Appeal overturned the decision, saying that structural interdicts were not part of Kenya. So the Supreme Court affirmed that indeed they are applicable in Kenya. However, sometimes this year, there is the Omtata Tribunal's case. I think it was Omtata versus the National Assembly, where the court in the first instance had issued a structural interdict directing the National Assembly to come up with a tribunal's bill. And what the Supreme Court did is set aside that structural interdict that had been given against Parliament, and it held that, in part, structural remedies must remain exceptional, proportionate, realistic, and restrained, and that judicial intervention in legislative process is justified only in the clearest of cases. So it appears there are different standards the Supreme Court has given for executive and legislature. So I would want to hear your views on whether we should maintain that the standard for judicial supervision on legislative processes should be higher than that of the executive supervision of executive compliance of court orders. And if so, what is your basis? What is your response, if it's yes or no, and give your explanation.
The Commissioner, so first of all, let me just answer the last limb of your question directly. Yes, I would think that violate separation of functions, it would amount to micromanaging the legislature. And probably just two more observations about it is to say that the general nature of how the courts deal with legislative output is to wait for it to be finalized. You don't go in and say, do your second reading today, or take it to public participation today. You let them run the whole process, and when it comes to court is when you evaluate whether it was done properly or not, whether there was public participation, whether it went through all the stages and all that. And so structural interdict would have that inverse effect. It would have the inverse effect of seemingly micromanaging the legislature. And lastly, being a letter decision from the Supreme Court, I sometimes wonder whether the latest from the case of over 30% gender representation in all government entities, including legislature, where the court had said you must immediately apply the 30% plus, and it has never been achieved up to today. Whether that was a lesson also to say, handle only what you can handle. Supreme Court is being more measured in how it is relating with the legislature in this decision of Okio Mutata, saying
you know that the Supreme Court is managed on a regulatory framework.
Yes.
What are the challenges, if any, that when you look at the Supreme Court, it has in its regulatory framework, and there have proposals over the year that there needs to be some constitutional amendments to the structure of the Supreme Court, including to increase the numbers of the Supreme Court, to bring a limited term to the Supreme Court, for Supreme Court judges not any term, because it's such a political court. This issue you are discussing with Justice Mirima, whether you can leapfrog certain issues like constitutionality of statute, that perhaps it should leapfrog from the High Court to the Supreme Court, and also the budget of the Supreme Court, that in other Supreme Courts they have an independent budget, and that's not the case here. What is your comment on these kind of amendments, and do you have anything else that you would look at the regulatory framework and say, this is the direction in which the Supreme Court should do, and if you come to the Supreme Court, that you'll be able to support such change?
Okay, so the question is more administrative than legal.
Yes, we have now moved from legal.
Okay.
We are still an institution.
Yeah.
We have our administrative issues.
Yes. I think the other suggestion also was to ask that the Supreme Court the number of judges should be increased from 7. I think that's one other suggestion.
Oh, and one final, yes, that the number of days to listen to the presidential election petition should be increased. What do you think of that?
Okay, okay, so I'll just answer from my feet, because it's not something I've really thought about. I know the discussion has been more in the nature of the numbers of the Supreme Court number of judges. But then your question would be on the leapfrog. I think I maintain the position I took in my conversation with Justice Murima, being that the Supreme Court is one more set of minds on an issue. And it is better if by the time it is scaling to the Supreme Court is able to look panoramically at all the thoughts that have gone into the issue, and to be able to adjudicate and give directions. And so I would still restrain myself from saying the leapfrogging would be a wise thought. On the issue of 10 years, yeah, probably it's a good idea. And I'm just answering this on my feet, my lady. It's not something I have thought. The other option is probably to do what ICC does. The ICC doesn't have so the ICC has 3 levels. It has a pre-trial level, it has a trial level, and it has appeal level. But there are no trial or appeal level judges. What happens is they rotate. So that you would be today a pre-trial judge, next month or probably after a term of 2 years, you move to the appeal level, then you come back to trial court. That's probably another consideration, so that the term doesn't need to be 10, but and the difference then in the ICC vis-a-vis Kenya would be, the difference is the number of minds, because if a matter is being considered at trial level by 3 judges, when it goes to the appellate level, it is 5 judges. So the difference is the number of minds rather than the seeming, it's not a question of cadre, rather it is the amount, the volume of mind material that is applied to the issue. So instead of the 10 years, probably my thought would have been to consider a possibility of having a rotational situation. On budget, I think that would be creating too much class. I know this probably is unpopular, but I think if the Supreme Court was to have a separate budget from the rest of the judiciary, then it would border on a statement saying this is a special court and it's not part of the judiciary. I would rather that they remain part of the judiciary. I hope I have answered your questions.
That's enough. Thank you very
lady.
much. That's all, CJ. Thank you.
Thank you, Chair. Good afternoon once again.
Good afternoon, Your Honor.
I hope you are not tired. It's been a long day.
I am okay. I'm okay.
Okay, so you are now a member of the bench.
Yes.
And so when we are to evaluate your performance, it has to be evidence-based because we have a system for measuring that. But unfortunately, I find myself a bit handicapped. I have your report here from DISPOP, which basically captures data on the benches that you have sat in since you were appointed as a judge of the Court of Appeal. I think that's hardly 3 months now.
Yes.
Has it?
Yes,
I
yes.
think it's about 3 months.
Yes, Commissioner.
Yes, so there isn't much I can engage you on, save to say that you have some non-merit resolutions in the benches that you have sat, and you have had just a few sittings in the Nairobi Civil Appeal Division, the Criminal Division, and also Nyeri Court of Appeal. I heard you mention, though, that you have done one merit resolution.
Yes, so let me explain that. I'm yet to get quite familiar with the terminologies, but this is the scenario in terms of performance. I have served in terms of being on duty, and I think that's fairly routine. I have also sat on single judge matters, and I can say this for a fact that I have no pending single judge matter except the ones that were listed, that were coming up today and yesterday. And those ones are scheduled for delivery next week. And so for those ones where I am fully in charge, I have nothing pending except those ones of yesterday and today because I was in the course list. In respect to the others, as you appreciate, it is collegially, you have to do the draft, to circulate, get approvals, and so those ones are still going through the circles. I think my first ones would become due from mid-May.
Okay.
Yes.
Okay, maybe then we can discuss something else.
Yes.
As you probably know, performance measurement has had a long history in this institution. We came from a period when we were violently opposed to the idea of measuring a judge's performance to where we are now, where we have a framework that does that. Now, what I want to ask you is whether there is a legal framework underpinning the need to measure performance in our judiciary. Do we have a legal framework?
Yes, I would say I would refer to the Constitution and say the need for transparency, the need for accountability to the public is such that it should be possible to evaluate and determine whether taxpayers' money designated for judiciary is value for money. And I would anchor my contention on the need for performance on the requirements of the Constitution that there is need for accountability, financial probity, and and performance. I would also say that the requirement that that would be my argument. I would say performance is anchored in the need to be accountable to the public.
Yes. Okay.
Yes.
Sorry. You're done?
Yes.
Okay. And there's also the Judicial Service Act, Section 5.
Yes.
That requires us annually through the Chief Justice to give a State of the Judiciary and Administration of Justice report.
Yes.
Which basically, of course, stems from the performance measurement that we do.
Yes.
Now,
I probably just wanted to say this, but I wasn't sure whether I should say it or not. But let me just say it now.
I thought you wanted to say it, yes.
Yes.
You started
I
saying
think there is the pending question of quantity versus quality. I think it's something that probably still needs attention. The criteria for determining that the amount, the statistical return on the numbers is not enough, that there is also need to determine the quality of the output. I just wanted to put that additional comment.
Okay. I thought you said you wanted to talk about Section 5 of the JS Act.
I also wanted to say that.
Okay. So the arguments that we had as we were developing this concept in the judiciary was the fear or the concern that this would sort of interfere with the independence of individual judges, because as a judge or as a judicial officer or anyone discharging judicial function, you are supposed to do the same without fear, favor, or any kind of pressure or direction. Now, in your view, are there any safeguards against interference with the independence of judges in the current framework that we have? If you have any, you can mention them. And the second limb of my question, where then is the balance between measuring performance and safeguards, if there are any?
The only argument I would make around that issue is I have no doubt in my mind that there is need to measure performance, and there is need to require the judiciary to demonstrate that they have delivered on it. I have no doubt about that. I think it's the question of how you balance the intricacies around it. And I would think the conversation should be more in saying, are the targets placed on the judges and magistrates too onerous to a point where, in consequence, they look more at making determination even where quality could be sacrificed so that you meet targets. So I think the conversation should be more whether the targets have been balanced in a way that it doesn't place pressure to a point of diminishing the quality of the work done. I would think the conversation would be more there than whether or not there is need for performance. And that's where the balance, I think, needs to be placed.
Okay, that's where the balance, but do we have any safeguards in our laws, maybe statutory?
Yes.
Or even constitutional?
Yes.
To protect or to safeguard the independence of the individual judges and judicial officers vis-a-vis measuring their performance?
Yes, the general proposition that they have judicial independence, I think, is, and the fact that judicial independence right is protected in itself, I think, is the countermeasure to ensure that. And then probably a little more on the judges, also the security of tenure, the process of recruitment, and the budget arrangement for the judiciary. All those, I think, give some level of cushion to protect the judicial officers and the judges.
Okay. Thank you, and I wish you well.
Thank you very much.
Thank you, Honorable Chair. Honorable Judge, I know you've been on that seat for too long, yes. But don't worry, we're about to finish, so my session will not take too long. And now, please address us on the tension between judicial independence and judicial accountability, and tell us how the tension is managed at the level of the Supreme Court, where there is no higher court or where there is no further appeal.
Judicial independence and judicial accountability, I think, is probably the conversation we've just had with the previous interviewer, being the need to arrange so that the judiciary is not such that it is a castle, it is a lord unto itself, but is accountable to the public. And so, to my mind, it's a question of just balancing that in the quest to ensure that there is delivery of services, pressure is not placed to a point where the quality of work is diminished. But that independence is necessary and accountability is necessary. And to the extent that your question is, the tension is that my view is that they have to coexist. So somehow they have to find a balance, because both of them are necessary to be to the taxpayers. In terms of the Supreme Court, I think the quality of the work done, I should imagine also that they also have policies on targets of what they are supposed to achieve in terms of timelines and things like that. And I think that still takes care of any concerns that they are not accountable to anybody. But importantly, I think they are accountable in terms of the need to present the state of the judiciary, the need to make presentations to Parliament, the need to justify budgets, and also the public, the access of the public to see their performance is a countermeasure that ensures that the Supreme Court delivers on its mandate reasonably, within time, and to the quality.
Okay. How is the Constitution provided for the independence of the judiciary?
So the independence of the judiciary in the Constitution would include issues like what we are going through, the procedure for recruiting judges, that it is open and public, and the evaluation of the competence is merit-based. There is security of tenure. There is separation of the budget for the judiciary. Those ones come to mind immediately.
Okay, thank you. I'm satisfied. I'm satisfied with those.
Thank you.
The final question from me, I have looked at your choice of referees.
Yes.
You're positively and highly recommended by the referees you provided. And indeed, I can say you know people. So now, given this as a judge of the Supreme Court, if you are to receive a phone call or a message from a senior state officer in regards to a matter that is before the court, how would you go about that situation?
Okay, I would do what the law requires me to do. I would apply the law to the facts, and it doesn't matter what message or call I have received. I would remain faithful to my calling and to my oath of office.
Would you honor that engagement?
No.
Or discussion?
No, I wouldn't.
Okay. Thank you, and I wish you well, Judge.
Thank you too.
Thank you, Honorable Chair, and welcome again, Judge.
Yes.
Yeah, I have two questions for you. Very, very brief. Now, the judiciary is increasingly adapting digital systems such as e-filing, virtual hearings, and automated case management platforms. While these reforms promise efficiency gains, they also raise concerns about digital exclusion, cybersecurity risk, and over-reliance on technology vendors. How should the Supreme Court guide the judiciary in balancing technological modernization with constitutional guarantees of access to justice and data protection, especially for vulnerable and digitally marginalized groups?
Okay, so thank you. I think it's a question of continuously being diligently conscious of the environment we are in, and always looking out to make sure that some segment of the population is not left out. And in that regard, I think the concept contained in the statute is a very useful one, because it endeavors to reach those ones whose access to technology and whose geographical locations may be so far flung off to a point where they might be excluded from the judicial process. So I would think that the Supreme Court, where occasion arises, would also encourage those that kind of enterprise contained in the statute, the ADR and the AGS. On the technology, on cybercrime, I think it is also a question of diligence, remaining very vigilant to make sure that the technology deployed are up to date to a point where it doesn't expose the judicial functioning to the risk of cybercrime and hijacking and frustration.
Okay.
Yes.
Now, in circumstances where a constitutionally sound decision is likely to be unpopular and could create or trigger a political backlash, how would you uphold integrity, impartiality, while maintaining the court institutional legitimacy?
Okay, I understand the question, Commissioner, to be what I would do if there is a, what did you?
There's a case before you.
Yes.
And the decision would actually trigger a political backlash. So how would you maintain or even uphold integrity while maintaining the court institutional legitimacy? The decision might likely
I
be
got the question,
unpopular.
No? Yes. You could even replace that by saying the LGBTQ case. Okay. My view of it is that it just calls on the judges to make sure that they reflect deeply and profoundly on what the issue is, and make sure that the judgment speaks for itself, to the extent that anybody who is honest about it looks at it and says in good conscience that indeed the output from the reasoning of the judges is what the law says, and it doesn't matter that it is unpopular. What matters is that the law has been applied, and I can think of a number of cases like the LGBTQ case, the issue of CDF. The judiciary had to deal with adverse view, but I think the quality of the judgment, the way the judgment speaks for itself, speaks well for the judiciary, and helps therefore to maintain the integrity of the judiciary and the perpetuation of the judiciary, being faithful to the calling and being diligent in the work.
Okay. Thank you. I wish you all the best.
Thank you very much.
Yes, good afternoon again.
Good afternoon, Vice Chair.
Yes, I know it's quite long, but almost through with it.
Thank you.
Now, on global issues, how does globalization affect constitutional law?
Globalization affect?
How does globalization affect constitutional law?
Constitutional law. Yes. Okay, so globalization, thank you for the question. I think globalization affects the constitution in the sense that even when you have the law, the constitution in place, issues of other jurisprudence come in, and you keep needing to cross-reference it to the constitution. And for instance, the case of BBI stands out very prominently on this, that the constitution is there, it has provided for how it is to be executed, it provides for how it is to be amended. And then an argument is introduced on basic structure. And so you can see immediately the globalization is already integrating with the constitution. And so in answer to your question, yes, the globalization affects the constitution, and the function of the judiciary is to be always on lookout and borrow what is possible and reject what is not in tandem with the constitution. And sometimes see the extent to which they can coexist. That would be my answer, Vice Chair.
How can the judiciary benefit from global networking?
I think it would benefit, first of all, in manpower improvement. The network could be such that knowledge is received and is passed on between the involved parties in the network. I think it would also help in terms of, so that would be, first of all, personnel capacity. There would be also resource input from partners, and I would think of those two as the important outputs, and also the hybrid of the law that comes then from that kind of integration and relationship.
Thank you, Honorable Sija.
Thank you, Chair, Vice Chair.
A microphone, sorry. Thank you very much, Commissioners and Judge. I believe you are very tired by now.
I'm okay, my lady.
But we are about to complete. Just one clarification from you. When we called out for the applications, there was a list of documents you are supposed to provide. We called for these applications. The advertisement was on 13th January, and it was closing on the 17th of February. And we give instructions on how you are to apply and the documents you provide. The list of documents are many. You provided others, except you did not provide a current declaration of income and liabilities as at the making of the application using the prescribed form. What you gave us was a previous declaration you had made for the Court of Appeal, which is dated income for the period 20th January 2025 to 31st December 2025. You are
my
supposed
lady,
to
do I have your
fill in
permission to refer to?
To refer to the.
I have a copy.
Yes, I think that's the one I'm also referring to, the one you filed.
Yes, which page, my lady?
The one I have, show him. Yes, you have seen what I meant, that you are supposed to, when you were making the application, you were supposed to fill in that form for that period when you were applying.
Yes, my lady. I have been shown by the registrar. As you can see, the declaration is dated January 2026, I think, which is the date it was filled. And the status of the assets between the time I made the previous application and the time I made this application, the assets had not changed. And so that is the answer I have for that. Secondly, my lady, is that my understanding of it is that the world declaration intervals would be after 2 years, and but the declaration I had already made, I had labored under the impression was adequate to that extent. So those two reasons, my lady, that the assets had not changed, and secondly that it was still within the time of my last declaration.
Yes, you see, this was a requirement for the application, for every applicant.
Yes, my lady.
To complete that form, even though you had completed earlier, you should have just completed and said the assets are the same, completed and followed the instructions as per the advertisement.
Yes, my lady. My understanding is that I'm in compliance, although I stand to be corrected. My understanding is that I'm in compliance to the extent to which to the extent to which I've just explained in the answer I've just given,
yes.
my lady. Let me not belabor the issue.
Very well.
Thank you.
So I think this brings us to the end of the interview this afternoon. Sorry it has been drawn over the time that we had dedicated, but I think the commissioners were interested in proving your suitability. So this is the opportunity we give you also to engage us.
Thank you, Chair. I just want to say thank you very much for finding me deserving to be shortlisted, for the opportunity to appear before you, and for the courtesy you have extended to me in the questions asked. I want to say thank you very much and wish you well also in the process of doing the evaluation and determining the suitable candidate. Thank you very much, everybody.
Okay.
Yes.
On behalf of the commissioners, we also wish you well, and we wish you success in all your endeavors. We will get in touch with you when we complete the exercise.
Thank you very much.
Yes,
thank you.
We are now releasing